Can you hear and see me, Mr. Chairman?
Dr. Brash, good morning. I can hear you. Are we expecting Stephen as well?
Actually, to be Brigette Morton, also from Frank's Ogilvy. Yeah. She should, I think, be waiting there to take part.
Wait, Brigette is in the room. Here we go, Brigette.
I see the Dark Lord has got himself an apprentice.
Morning. Okay, I can see Dr. Brash. I can't see Brigette. Oh, there you go. I can see Brigette. Good morning. So good morning to you both. Thank you for being with us. We do have you with us for up to 10 minutes this morning. So if you can begin your oral submission, we appreciate that.
Thank you very much. As you say, I'm Don Brash. I'm one of two spokespeople for the Hobson's Pledge Trust. Hobson's Pledge is an advocacy group with some 140,000 supporters. We're named after Governor Hobson, who of course said in the Maori language, as each chief signed the treaty, we are now one people, and that's what we fundamentally believe. Hobson's Pledge supports this bill. When Parliament passed the Marine and Coastal Area Act back in 2011, it was confidently asserted by both the Prime Minister and the then Minister, Chris Finlayson, that there would be successful claims by iwi for customary marine title around the coastline, but they would be rare because they would need to display continuous and exclusive use of that piece of coastline since 1840. The courts have clearly reinterpreted the meaning of exclusive. They've added a concept called shared exclusivity, which makes a total mockery of what Parliament intended. So we feel strongly supportive of this bill as it tends to amend the original Marine and Coastal Area Act. Having said that, if we had a choice, we'd go back to the Foreshore and Seabed Act in 2004, where the Crown owns the foreshore and seabed on behalf of all New Zealanders. But that isn't on the table, so we support this bill. And Brigette will add some comments about some specific details which we think would improve the bill.
Thanks, Don. So I'm Brigette Morton from Frank's Ogilvy. We act for Hobson's Pledge, but we also act for the Landowners Coalition, who is an interested party in the Edwards matter, which comes up before the Supreme Court next week. They are submitting separately, so I'm not going to speak directly to their views on the bill, but being informed by our participation in MACA hearings over the last 5 years in particular, we produced a legal opinion for Hobson's Pledge, just drawing attention to some aspects of the bill that we think could frustrate the purpose of the bill. I want to leave as much time for questions as possible, but I wanted to particularly draw the committee's attention to this opinion. It is its supplementary one of the submission, and particularly to paragraphs 33 to 51. This is where we talk about the role of tikanga.
Oh, no.
In brief, there's a two-stage test that has been established for customary marine title. Tikanga is explicitly taken into account in the first limb, and the courts in the Edwards proceedings has read in the second limb. The Minister has been very explicit that they wish to take the test back to what is originally Parliament's explicit wording. Unfortunately, we do not think the mechanism in which this bill does that, which is the new subsection 1, capital A, where it removes any consideration of spiritual or cultural considerations, will do so, and just draw the committee's attention, as I say, to the role of tikanga and how courts have treated tikanga as something beyond a spiritual or cultural norm within our law. But happy to take any questions.
Thank you, Brigette. Dr. Brash. So members, just so we can get the process right. About that, it's just double checking. If you have a question, please indicate by using the raise hand icon, and then I can pick that up from the side that's there. So first question is from Dr. Duncan.
Kia ora, Mr. Chair. Thank you for that, and interested to hear those submissions. I'm just a little interested in your views around customary rights. I think I've got probably two questions if I've got time. One is kind of more philosophical. Given that the customary right, if established, is simply recognising a property right which has existed from 1840 on. What is the kind of underpinning for suggesting that that property right should be expropriated without compensation, with a return to the original Act?
Bridget, you going to answer that?
I think I'm not sure if you're referring to this particular amendment bill that seeks to take away any customary marine title that has been already, in some parts, been already awarded, or are you talking about if there was a return to the Foreshore and Seabed Act?
Well, the Foreshore and I'm really referring to the Foreshore and Seabed Act, but it's fair to say that even if this amendment was passed, there are people who have litigation in train who would have rights deprived from them, which have essentially crystallised, which would pretty much fit the definition of expropriation. And I'm just really perplexed, given Hobson's pledge reputation for being an upholder of property rights, that you'd want to see them removed.
I don't think there's any suggestion that we want to reverse existing decisions of the court. My understanding is that those will stand. What we're saying is where the court has not made a decision, the courts should be guided by what Parliament intended. And right now they're not being guided by that intention.
Well, that's not exactly how the legislation works, and it's clearly been recognised as retrospective. But let me go to my next question, and I'm just curious about your stance on concurrent exclusive rights, because it's pretty well established, and in fact English law has long recognised the ability to have concurrent rights into a single piece of property, whether that be a right to hunt deer for one person and cut wood for another, which is, the old law of the forest, or simply land law, where you can have licenses in respect of the same land to do different activities on it, mine it and farm it. So I'm really perplexed as to why you say concurrent rights in respect of marine areas are foreign to the law, when clearly it's well recognised.
So I will take that question. I think there's a difference between different use rights in terms of property rights and shared exclusivity. So in this context, we're looking at multiple iwi or hapu having the same rights, say collection of seafood or fishing rights, or the ability to place rahui on a particular coastline. So they're not independent of each other. They can be the same right over the same area.
Can I just clarify then, if one iwi had a right to collect shellfish and the other had a right of passage with their waka, would you accept that we should have a piece of legislation which recognises those as customary rights which can coexist?
So they would still need to meet the test under the law, which they need to show uninterrupted exclusive use throughout. So therefore, if the ability to launch and the ability to collect Moana.
Go ahead.
No, let it finish. Tukata Ferris is gonna cook her in a moment.
Yep. Oh, okay.
Were able to operate without having interrupted each other's use, then that would indicate that is allowable under the MACA.
All right. Okay, thank you. We'll let someone else ask a question.
Okay, before Takutai Ferris literally sits down there and reads the Riot Act, does it just feel a bit bland and like they have to think about their answers? There's no talking points?
Yeah, let's get, you think Don Brash, he's like, oh, William Hobson said this thing. Say the thing he said. Go on. He iwi tahi tātou. Now point to where that is established in the treaty. Okay? I mean, for all I care, William Hobson could have said skibbity toilet to every chief that walked on up. Does that have any legal binding? Is that what the rangatira agreed to? No, they agreed to what they signed.
Yep.
You're very quiet, Chris.
No, this is quite interesting, because I have not kept up with the foreshore and seabed over the years, but this whole thing just reeks of expropriation of customary title that kind of goes back to the Māori land courts of the 1870s onwards, and it's like this is just a continuation of that very Eurocentric idea of there can only be one. It's like, why can there only be one when Te Ao Māori accepts that there can be many and shared, and it's not tied up in this notion of exclusivity?
I want to know why the libertarian, Mr. Don Brash, or Dr. Don Brash, as I should call him. I better call him Doctor, otherwise his lawyer's going to get on to me. I want to know why he thinks it's okay for the government to hold on to land that was seized via the New Zealand Settlements Act of 1863 and the Native Land Rating Act of 1882, which unfairly put higher rates on Māori land compared to Pākehā land. That's not libertarian, if he's supporting that. That's authoritarian.
Okay, let's continue.
Question from you.
Takutai has his hand up.
Yep, I'm calling for
I've got to say, the use of the technology is still not
Chair,
good.
you're not being heard well
Okay.
through the.
Oh, I apologise. Hang on one sec. Sorry about this. Question from Takutai.
Tēnā koe te che. Tēnā koe Takutai Brash. Korua koto hoa.
Careful, he might ignite some fire.
Questions, but I'll just ask you a couple here. With regard to your framing and approach to the marine and coastal areas built, do you think that, or do you deem customary title, which Māori have been allowed to pursue within the parameters of the law, equates to ownership or some form of ownership?
Well, it's clearly a kind of ownership. It enables the group which
It's concept of ownership
to exclude others under certain circumstances. So it clearly is a form of ownership.
Or killed up, so it's a form of ownership. Māori have long utilised their own coasts in conjunction with neighbouring iwi and iwi that they may have had a relationship with who lived way in the mountains. At the arrival of early Europeans, Māori continued to share the use of their coasts with those new people. In 2004, all of the rights that Māori possessed relative to the coasts that they occupied were confiscated. And a test was established, the exclusivity test. Now, I would implore you to consider that Māori have the right to share their coasts with whoever they deem suitable, while still maintaining their mana over that same coast. So that's a Māori point of view that I would really like to hear what you have to say about it.
It's also a Pākehā point of view too, when you think about it.
Yep.
So you have to share land.
I'm not quite sure what I would say about that, but clearly it's been long established that no, I'm not sure how to answer that question. I need to take it on notice, I'm afraid.
Yeah, probably would have thought about it.
Have a view as to what I've presented?
I think if you look at the experience of the MAC hearings to date and the applicants' evidence that they have put forward, that there may be some circumstances in which that has occurred where there has been agreement, and that would not, I don't believe, necessarily mean that there's been substantial interruption where there's been agreement of use. But you see through the competing of applications that actually there's many iwi and hapu that have not agreed use and actually have declared separate applications and separate evidence as to their own exclusive use.
Do you, just quickly then, I don't want to take up all the time. Just quickly, do you think that declaration of exclusive use has come about as a case of Pākehā law?
Ting.
So
There it
we are
is.
operating.
In response to, sorry. So iwi and hapu who have put in exclusive claims excluding a neighboring hapu or iwi, do you think that that's a symptom of having to deal through Pākehā law?
And
So
the
as a
response?
lawyer, I operate under what the law set by the New Zealand Parliament. I don't define the difference between Pākehā and non-Pākehā law.
So any
That is the end of our time. Apologies for the audio issues before. So thank you to Dr. Brash and Brigette.
I want to point something out really interesting. I've got this in my notes about English common law. So English common law, and unfortunately I can't really share the link to the research here, but it's from Auckland University. English common law was developed to accept that when English law is transposed onto a new country, the laws of the indigenous inhabitants survived the assumption of British sovereignty. I think that's a really interesting component of English common law that I think is being ignored here.
Yeah, there's a whole lot of stuff that's being ignored in this very simplistic approach to things, and I wonder, the whole idea of the fee simple idea of owning land, that survives whether you're in occupation or not, and it survives all sorts of things so long as you pay your dues. Then nobody's going to claim that you don't own it or don't have an exclusive right that is continuous just because you don't live there. It seems there's some very high bar that's being set here for a group who predates an agreement, being Te Tiriti, to prove that they've had an ongoing interest in the area. And indeed that came up with one or two of the other submitters who basically put forward precisely that point. Just because we've been unable to get there or are no longer resident there does not mean that our interest in the area has been wiped away, extinguished.
Yeah, that's true. That's true. A Kiwi Skirt in the chat said that didn't make much sense. So basically it means that when you apply English common law, right, it makes provisions for indigenous law to stay intact, so tikanga. So that's a really interesting part of British common law right there. So basically with the signing of the treaty, and I'm not a lawyer, so please don't quote me on this, but yeah, basically with the signing of the treaty, part of that under English common law also acknowledged the tikanga that Māori, the rangatira, also followed when it came to land use.
Whenever I hear common law, the most common place I remember hearing about common law was on the TV show Judge Judy. Because many of the practices she used was English common law when it came to her rulings.
Yeah.
So when I keep hearing common law, I ultimately think of Judge Judy. I don't actually think of, the whole process of what's been here.